Hey, so something's weird with my screen. It looks kind of like dreamy-like. I guarantee this is not dreamy. Might put you to sleep. All right, so there are some things to remember for the con structure exam. So the first thing is, here are the major topics that we covered. Sovereign immunity, executive power, original and appellate jurisdiction of the Supreme Court, the federal Supreme Court, adequate and independent state grounds, justiciability, which is standing, ripeness, mootness, and political questions, the enumerated powers, which mainly we talked about the commerce power, Dormant Commerce Clause, taxing power, and spending power. We also have privileges and immunities, which ties in with the Dormant Commerce Clause, especially the market participant exception. And then we talked about intergovernmental immunities. So here are some questions to remember for those things when you're seeing with the case. You're going to ask yourself, is there standing? Do you see an injury in fact? Is an injury in fact likely? Then it might be ripeness. Is there concrete harm? Is there individualized harm? Will a judicial decision solve the injury? Is someone opposing a tax itself? Then yes, they can have standing. Are they opposing the spending of the tax? Then no, they cannot have standing, with the exception of the separation of church and state, the Establishment Clause. Then, is there mootness? If it can be judicially decided. If there can't, it's moot. Okay, so you're going to look, are there collateral consequences that even if the behavior has stopped, the harm has not? Did someone voluntarily stop the action to cause it to be moot, in which case it may not be? Is there a class or representative that was certified? Is it capable of repetition but evading review? Can it reach a remedy? You're going to look for ripeness. Is it too early to bring it to court? Is it a statute that has never been enforced? Is it a statute that threatens harm? Has someone else been prosecuted for something that you've been doing? Those are all things that might tell you ripeness. Professor McGoldrick said, look for murky language. Then we've got sovereign immunity issues, which are the 11th Amendment. Is it a private citizen trying to sue the state? Then no, they can't. Is it a state suing a state? Then yes, they can. Is it a county or a city that a private entity is suing? A private entity can sue a city or county. That's fine. They can only not sue a state. Then we're going to look for the stripping doctrine. If it is a state official, but they are named and they are being sued because they are violating a federal law, and it's to stop them from violating a federal law. In that case, the stripping doctrine comes and you can sue them. Did Congress abrogate the issue? That means this is the Seminole Tribe case. Generally, they cannot abrogate. In due process or equal protection, they can. Probably not going to see that, but keep your eye out. Is there a political question? Is this is something that is relegated to the other branches of government to solve, or can only be redressed through a vote? Then we have executive power. Did the executive have a treaty, or was it an executive agreement? Does this have to do with principal or inferior appointments? Is Congress asking that the executive gets their permission to remove someone? That's not allowed. Does it deal with executive privilege and sharing of private conversations? Then you're going to look. If you see a law, a federal law, you're going to ask, does it go back to an enumerated power? Look for the look if this affects commerce. You're going to look if it substantially affects, or if Congress can rationally believe it can affect. The Commerce Clause is the one with the least amount of parameters, so that's the one that's going to come up most. Then you're going to ask, are the feds saying someone must purchase something? That was the Cebulus case, and the answer is no, they can't make you purchase anything. That case was decided as a tax, not a purchase. So no, the federal government can't make you purchase something. It is invalid. Is Congress compelling a state to regulate something? No, they cannot do that either. Then we're looking at taxing power. Does the tax bring in revenue? Does it bring in revenue and regulate? It's completely allowed to regulate, even if revenue is only negligible. Does it act like a tax? Does it look like a tax? Is the IRS collecting it? If it looks like a tax and acts like a tax, it's probably a tax. Even if it's called a penalty, as long as it's not overly punitive, they'll let it go. Spending can be for the general welfare. The general welfare is only for spending. You cannot legislate through the general welfare. But Congress can spend for the general welfare. But there may be conditions on the federal money. That is fine as long as it's not in the face of the grant and it is not coercive. And the conditions must be necessary and proper, which means they must be related to the stated end goal for the general welfare. It cannot be coercive, and you cannot make the state act like a regulating body or a police force. Then you're going to look for the Dormant Commerce Clause. Is the state trying to regulate something that the feds have already regulated? You're going to look, is what the state is trying to do discriminatory against other states? Then it is per se invalid. Is it unduly burdening? If it has a legitimate state end, you are going to balance the undue burden with the legitimate state end and see if it's rationally related to that legitimate state end, and you're going to come to an agreement to, is it unduly burdening or not? Is it a market participant? Is it selling something, buying something, or employing someone? Then it's allowed to be discriminatory. But if it's regulating downstream, not okay. They have to be a market participant, not a regulator. A tax is always a regulation. It is never a market participant. Then you're going to look, did Congress preempt this issue? They can do it expressly by saying they're in charge of everything, or they can imply it through field. You're going to look for field and conflict preemption. Normally, is this something that's normally a state issue? If so, the court is going to presume that the state gets to regulate it. Is there a market participant? Is it about an employee? If so, look for privileges and immunity. I'll go into further depth. This is just questions to ask yourself. Does Congress consent to... did Congress give express permission for the states to regulate, even against what they said in the past? Because Congress can do that. Then you're going to look at for intergovernmental immunity. This is the feds cannot make the state its enforcer. And the feds cannot regulate... the feds have the authority to regulate public state government entities just as they would a private entity. There's also adequate and independent grounds. Is there a state and federal ground? Has it been fully decided by the state issue? If not, the Supreme Court cannot review. But if the state court is decided on in a federal constitutional issue or on a state constitutional issue, if the state constitution mirrors the federal constitution, then the state cannot decide it on their own factors. The Supreme Court then can do that. We'll go more in depth when I read some rule statements. Jurisdiction, Supreme Court has original jurisdiction over foreign governments that are suing us, and suits where the state is a party by the Constitution. Those are the only original jurisdiction that the Supreme Court can have. But with the appellate court, Congress has almost unlimited power to change its jurisdiction. So it can start and stop whatever it wants. And as always, the federal law is always supreme over inconsistent state law. You should have that at least once in tomorrow's exam. Federal law is always supreme over inconsistent state law. All right, some rule statements. Sovereign immunity. Rule: a private entity cannot sue a state in federal court without its consent. A state employee in their official capacity can also not be sued for doing or not doing their job. The exception is the stripping doctrine. A named state official to enjoin, declare, or injunct can be sued for violating a federal law or a constitutional right. They cannot sue them for damages. An exception to this is Congress can explicitly say they will allow abrogation only for due process and equal protection, and this will allow for damages. We probably will not see that because we know nothing about due process or equal protection at this point. Executive power. The executive branch gets power from the Constitution, history, and Congress. The president has appointment power to appoint all principal appointments and some inferior. Okay. Inferior appointments can also be done by Congress can choose the head of their department may choose their inferior appointments, or the judiciary can choose inferior appointments. Those are more limited. That's all you probably need to know about that. Removal power. The executive has power to remove all principal appointments and some inferior if the position doesn't need to be removed from the president, because some of them need some freedom to not just be fired. Congress can ask for good cause, but they cannot require permission to remove someone. The president has executive privilege for certain communications. The exception is a criminal court. The exception to the exception is if the conversation has something to do with national security. Probably won't be allowed. Again, probably won't see that. Treaties and executive agreements. Treaties must be ratified by the legislature. Executive agreements do not need to be. Treaties trump older federal regulation. Executive agreements trump state law, but not federal. Jurisdiction. Supremacy clause. Valid federal laws always control over inconsistent state law. Federal laws are supreme over inconsistent state law all the time. Original jurisdiction. Supreme Court has original jurisdiction for representatives of foreign governments in cases where the state is a party. This is given by the Constitution, and Congress cannot change it. Congress has almost unlimited power to change appellate jurisdiction. The doctrine of adequate and independent state grounds. Rule: the Supreme Court can decide federal questions. Exception: the doctrine of adequate and independent state grounds. If a case has mixed federal and state issues and can be decided on state grounds, the federal court has no authority to review. Exception to the exception, where state grounds involve state constitution and the federal constitution. When it mirrors the federal constitution, the Supreme Court can hear it and it is not considered independent. Justiciability. Cases must be justiciable before ruling on the merits. Standing. A person to have standing to sue must have 1. An injury in fact. 2. An injury traceable to the complaint. 3. It needs to be able to get a personal remedy. A person can only litigate for their own constitutional issues. There is third-party standing, as well as taxpayer and legislative standing. There's also state standing, which is parent patriae. The state can always become the parent of its citizens, except when suing the federal court. Then the Fed has parent patriae. Mootness. Federal law cannot hear a moot case. The one that is no longer capable of judicial resolution. The exception, voluntary cessation, residual harm, capable of repetition but evading review, and class representations that have been certified. Ripeness. That means there is a sufficiently real threat of injury. Challenge laws on their face, not their aftermath. So it's a threat. Political questions. Issues only remedied through the political process, which is voting. Express, the Constitution says, like, this falls within this area. Or implied, we look at past cases to see political questions. Enumerated powers. Federal law must be pursuant to a enumerated power. Law must be merely necessary and proper to carry it out. It does not have to be. Anyway. Commerce power. Congress has the power to regulate anything that crosses state lines and anything that does not cross state lines but does substantially affect interstate commerce. This brings up the Dormant Commerce Clause. Congress has the power to regulate interstate commerce. Where Congress has not legislated, states can act, but they cannot discriminate against out-of-state commerce nor substantially affect interstate commerce. There's also taxing power. Congress can tax for any revenue purpose, and it may regulate. The exception is it cannot be punitive. Spending. Congress has the power to spend for the general welfare, but it cannot legislate for the general welfare. An exception, or to look out for, is that when they grant federal money, there can be conditions. It needs to be on the face of the grant, but it cannot be coercive, nor can it force the state to act as an enforcing arm. Coercive. Okay, intergovernmental immunities. Congress can regulate state and local government just as they can private entities. The exception, the federal government cannot force state or local government to be their enforcers. All right, so those are my rule statements. And last but not least, we got my quick outline. Constructure, federal versus state. We got federal jurisdiction, which covers sovereign immunity. Private entities cannot sue the state in federal court. Not the case in state. States have their own rules. This will include the stripping doctrine and an exception for abrogation for only due process or the Establishment Clause. No, Equal Protection Clause. We're not going to have that. It's okay. Separation of powers. The executive gets its power from Congress, Constitution, and history. The president can appoint inferior and principal appointments. Removal power. Sometimes the president can remove people. Congress can ask for a position to only be removed for good cause, and he has to accept that. But Congress cannot say you need their consent. President cannot seize industry, okay? And president has certain immunities and like no civil litigation, but what we're going to see in ours is not going to have that. And some of their conversations are privileged. Jurisdictions, supremacy clause. Federal law is always supreme over inconsistent state law. Yes, it is. Please know about original jurisdiction and appellate jurisdiction, the doctrine of adequate and independent state grounds, adequate and independent. You know the rule, the exception, and the exception to the exception. Justiciability is cases and controversies. It includes standing, injury in fact, capable of resolution. Injury is traceable to the complaint. We also have third-party standing. We have state standing, parens patriae, taxpayer standing, and standing about spending, but only for the Establishment Clause. See, that's where it goes. Then we have mootness, which means that it's not capable of judicial resolution anymore. The rule is Federal court cannot hear moot cases. There means there's been a change in the law or in the facts. There is an exception. Voluntary cessation, residual harm, capable of repetition but evading review, or class certification. Mootness, the case must be current through all legal proceedings. Ripeness is a sufficient threat. It needs to be a sufficiently real threat. You're going to look for murky words or difficult to pin it down. And it challenges the law on its face because there is not yet a true injury in fact, only a threatened one. There are political questions. Some are express, some are implied in the Constitution, all of them in the Constitution. These can only be remedied through the political process, which is voting. You're going to look for an enumerated power that gives the federal law. Federal law must be pursuant to an enumerated power every time, all the time. The law must be necessary and proper to reach that end of the enumerated power. The states do not have this restriction. The big ones we talked about in class were the commerce power, where Fed regulates, it preempts states' regulation. This can be done expressly, where the Feds say they are taking over that industry, or it can imply that it's taking it over, and you're going to look for the intent of Congress if they intended to preempt the whole field of what they're regulating or not. You're going to look for field preemption, where they don't leave any avenue for someone else to come in. And you're going to look for conflict preemption. Can both laws, state and federal, be followed? If not, the Fed is supreme. You're going to look if Congress meant to be uniform in the standard they were giving so that all states were uniform, or if they were just setting a minimum and the state can regulate above that. Okay. When commerce crosses state lines, it's called in commerce, and that is always allowed in the Commerce Clause. And when you're talking about in commerce, you're talking about channels of interstate commerce, which are roads, but it can also be misuse, like sending a bomb through the mail. I don't know why that's the case, but he said so. So keep it in the back of your mind. And then there's the instrumentalities, and those are like cars or trains or the things that cross interstate lines. And then you have commerce in only one state, but has a substantial impact on interstate commerce, can also be regulated. And with that, you're going to look for a substantial relationship. You're going to take a practical, factual evaluation and see if it is affecting interstate commerce. And if you're not sure, then you're going to do rational basis. And rational basis is the court saying, could Congress have rationally believed that it has affected interstate commerce? Probably, without major facts on the other side, probably. And then you're going to say direct, and the last test is a direct indirect test. Does it have a substantial effect or a negligible effect, inadvertent? That's the last one. He said Professor McGoldrick doesn't like that one. Only at the end, if you absolutely just throw it in there. Okay, then we have the Dormant Commerce Clause, and that is where the Fed has been silent. Can the state act? And you're going to look for discrimination to out-of-state things. And if there's discrimination, that is per se invalid. Now, the only time that if the state then says, no, we're discriminating not because it's out of state, but because it is different, and they give you a reason, then that makes the law even-handed, which means you have to do a balancing test. And that means you're going to balance the burden to interstate commerce, and you're going to balance that with the intended state interest and what the action you're doing relates to that intended state interest, and you're going to balance them. You're also going to add in a reasonable alternative that would not discriminate. So we're going to do all this, and you're going to come out with a conclusion. And then you're going to say, is there a direct, big, or indirect inadvertent burden? Constitutional limitations. Sometimes there's an express limitation, like export duties between the states, not allowed, or an implied one. There's going to be a textual thing. The courts you're going to look if the courts limit Congress has limited, do they want uniformity in what everyone's doing, or does it need diversity like ports? Congress legislation can overturn court, but not Constitution. So the Congress can always say yes to something, but it can't go against the Constitution. Constitution always guides. If the state, here's an exception to this whole thing, if the state is acting as a market participant that is buying, selling, or employing, acting like a private industry, it may discriminate, but it cannot regulate downstream of that sale or buying or employing. So it cannot regulate and participate. It has to do one or the other to be the exception of the participant. And and then when you're looking at the Dormant Commerce Clause, you can look at the cumulative or contradictory burden that it puts, that if that regulation were to be spread out and all the states were going to have that regulation, would it be much of a burden or too contradictory? Then the court may strike it down as well. And then you're also going to look, can the political process solve this issue? Is it so much about in-state that the state will fix it? That's like if it's in a city, and the rest of the state is also discriminated against, but that's usually invalid, so watch it. Privileges and immunity clause prevent states from Okay, so this is if there's a market participant and they're saying, well, we're employing just people from our city, then you're going to look at privileges and immunities, and this prevents states from discriminating against out-of-staters. This only applies to fundamental rights. A big one is working, but it could also be suing or living there or residing. It does not work with recreational activities like hunting or fishing, although if they're a work, then it does. It also does not apply to colleges, as we all know. Okay, if the state is saying they're discriminating, yes, but it's because what they're discriminating against is a different kind of evil and it has a substantial relationship to the problem they're trying to solve, it may be okay. You're going to look at the burden the burden is on the state to show it's a different kind of evil. And it's going to take some strict scrutiny, and the market participant is in the DCC, so that's where you're going to do that, but this is privileges and immunity, so there's no market participant exception to break the privileges and immunity. So it's kind of a catch-22 there. Taxing power. Tax can mix revenue and regulatory purposes. Only limits is what's imposed by the enumerated powers. If it reads like a tax, if it looks like a tax, if it acts like a tax, if Congress has an objective reason, it will probably be deemed a tax. If it's a penalty, as long as it's not, like you don't pay something, then you have to pay 10 times more, that is probably not going to go, but there's a lot of leeway. Spending power. Spending power can be for the general welfare. It can be as long as it's rationally believed it's for the general welfare. Congress can spend for general welfare. Congress cannot legislate for the general welfare. Congress can put conditions on federal funds. Conditions cannot be coercive. And the conditions must be unambiguous and on the face of the grant, and they must be related to the purpose. And then we've got tax. Taxpayers do not have standing to challenge spending power, but if it is an integrated tax and spending, they may have standing. Intergovernmental immunities. This is only seen when the state regulates the feds. Congress can regulate state and local government just as they can private entities. Exception, cannot use to force federal compliance. State can regulate Fed in like speed limits for postal trucks. So super small, inconsequential things. And that's everything. Breathe. Good luck. Have fun. The law is fun.